We have to recognize the presence of her worship the mayor. Kindly, sir. No, you are special. You are very special. I didn't see her because she was seated at my back, but I'm extremely sorry. The mayor of the city, the municipality is with us here. And we are blessed by your presence and we welcome you. Thank you.
The former deputy speaker and former opposition.
No. And the former ECOWAS speaker, but he's still a member of parliament. He's here also. So thank you very much for coming. Thank you very much for coming. We appreciate you and we love you. Chair.
Thank you very much, Mr. Clark. Leader of Government Business, Honorable Matthew Sanima. The Leader of the Opposition, Honorable Abdul Kaku. Rest of the parliamentary leadership here present. Colleague members of Parliament. The Attorney General, Minister of Justice. Her Worship, the Mayor, President Sixth Council. Representatives of political parties, former members of parliament, civil society organizations, fourth estate, distinguished ladies and gentlemen, good morning. Again, I want to welcome you on behalf of the parliamentary leadership to this very important pre-legislative engagement. The engagement on the bill entitled the Constitution of Sierra Leone Amendment Act 2025, being an act to amend the Constitution of Sierra Leone 1991, Act number 6 of 1991, and to provide for other related matters. I need not go over the procedures as already been stated by the clerk, but it's very important to remind all of us here the purpose of the session. During this session, the Attorney General and Minister of Justice is going to provide us a clear presentation on the merits of the bill. Honorable members at the back, may I have attention, please? Members will have the opportunity to broaden their understanding on the bill that's in front of us. And after the presentation, they will have an opportunity to ask questions, to seek clarifications or make suggestions. The AG has held so many other consultative meetings, but this time around, it's here in Parliament. So I want to encourage each and every one of you to listen carefully, take your notes, and then ask questions by the end of the presentation. Need not waste time, we go to the engagement program. At this juncture, I would like to invite statements, and the first one is going to be from the Leader of the Opposition, Honorable Abdul Kaku. Mr. Leader.
Thank you very much, the Chairman for the Legislative Committee. I want to join in sending my salutation to the Leader of Government Business, members of Parliament, the Deputy Speaker of the Parliament of Sierra Leone, the former Speaker of ECOWAS Parliament, leadership of Parliament, former members of Parliament, including my predecessor, the former Leader of the Opposition, the Mayor of the city, all flag bearer aspirants from all political parties.
We have flag bearers.
Yes.
Are you list? Are you doing this?
One of them is seated right with us on the item.
Yes, representatives from civil society organizations, government ministers, and staff of parliament. This is the most important privilege we've had in the 5th and the 6th Parliament of the Second Republic. Because this touches on the most important and sacred document of our state. So this is one of the reasons for which I think the consultation process, including the village, must not be only micromanaged by members of parliament. This document has to do with the public, and we should create conducive environment for the public also to have their say. I have always maintained the view that Sierra Leone does not belong to APC, neither does it belong to SNDP. Governments have come and gone, but it belongs to the people of this country. And one of the fundamentals in lawmaking is consultation, stakeholders consultation. So we want to seize this opportunity to listen to equally what the other stakeholders who do not belong to political parties will have to say about these amendments. But critically, we should not be oblivious of the constitutional provisions. In amending any clause in the Constitution, we should ensure that it is done by a resolution of 2/3 of members of parliament. In amending entrenched clauses as stated in section 108 of the Constitution, we should ensure that after securing the 2/3 approval in parliament, it should be subjected to referendum. In an event we fall short of any of these legal processes and procedures, we will be liable to treason. And when one's crime is committed, don't think if you are not judged during that very period you are safe. Don't think you are safe. Sierra Leone is a country of records. So to us in the opposition, we have expressed our absolute willingness. That was why even in the composition of the tripartite committee, which recommends most of the amendments, am I protected?
Order, honorable members. Thank you for your understanding.
That was an overtone. Yes, sir. The recommendations emanate from the amendments. Most of the amendments emanate from the recommendations in the tripartite that was constituted by both members of the APC and members of the SLPP of government. As we gave our unflinching support to our team that was sent, we equally expect that these amendments will reflect what was agreed upon by the two parties, save for those other important recommendations from the public. Like I said, this country does not belong to APC, neither does it belong to SLPP. So APC and SLPP should not think that they should dictate what should happen in the country without consultation to those who do not necessarily belong to these political parties. So accommodation must be made for stakeholders who may have one or two other recommendations to make. As I have always maintained, this parliament has never been rancorous, and we don't intend to make it rancorous. But we'll be very strict, we'll be very unapologetic in ensuring that processes and procedures are strictly followed. In electricals and electronics connections, they say I am an engineer, so I must be They say if you have two resistors connected in parallel and you inject any amount of current into those resistors, it is highly likely that the current will avoid the high resistor and go through the lesser resistor. If procedures and processes are not followed, or provide the highest resistance you could ever imagine. So to me, we are all young people. We are all young people. And one of the advantages of being a young person is that you have many years to live to see your legacy. Many years to live to see your legacy.
Order.
Honorable members, I believe when we are speaking, you should pay attention. You don't need undertones of comments. You are going to have your own tone, where you make your comments. When he's talking, I don't even make undertones, please. Let us listen carefully. He's talking about the unity of Parliament and the survival of our democracy. Please, let us give him attention. You did not allow him to talk about the anode and the cathode.
Thank you, Leader of Government Business. And I want to use the same opportunity to caution my members that whilst the Leader of Government speaks, he should not be interjected or procedurally interrupted as some members are doing now. Like I said, yeah, I'm questioning. Like I said, posterity will hold us responsible if we don't do what is correct. And we on this side,
It is your members that are giving order.
We on this side, I don't expect any member of Parliament to make any comment. We on this side, if the processes and procedures are compliant with what is entrenched in our constitution, we will fully support this process. But in a case that the processes and procedures are not compliant with what is in the constitution, we will not involve, we will recuse ourselves from the dangers that lie ahead. It's not a threat, except if somebody is of the opinion that this very amendment will not be compliant with the laws of Sierra Leone. So to me, one commendation I want to give to this parliament is that we have been very consultative on several occasions when issues rise up in parliament. We would come together, we'll hang it, and at the end of the day, we'll have a common meeting point. I hope and pray that procedure continues. Like I said, we on this side are not averse to this. I'm speaking on behalf of the opposition. We are not averse to this, but we would ensure that every bit of the process complies with the national law. I also made to understand that the bill presented to Parliament does not contain entrenched clauses. I want it to be clearly and abundantly made known to all of us that the bill we have seen has entrenched clauses. And we know what the process calls for in the case of an entrenched clause. It does not only stop at the 2/3 in Parliament, it extends to referendum. So on behalf of the opposition, I want to assure government of our fullest cooperation if the processes and procedures are lawful. But if they are not lawful, we will not cooperate. If they are not lawful,
Who is that? Who is that?
Order. Colleagues, honorable members, please, let's have them go. Please, let's continue, sir.
you see, they say old people feel uneasy when their bones are mentioned in the proverb. If you are very aware that the processes through which this constitutional amendment will be made are lawful, why would you even question? But again, I am saying this, and I want to be on record. I am saying this authoritatively, and I am saying this as the leader of the opposition that will not fall for anything that is not lawful. Have this at the back of your mind. Have this at the back of your mind. You say you will go ahead. We will not stop anybody from going ahead. So I'm making my position very clear. I'm not reacting to other things. But this should have constituted part of my statement. I'm rounding up. I'm rounding up. Yes. I'm not shouting. Okay, I'm not shouting. So like I said, we are making history. The 6th Parliament of the Second Republic is making history to touch the most important document in this country. Let us be judicious and let us make sure that we do the right thing for the people of this country. I thank you.
Thank you very much, leader, and for the statement. And I want to assure you, sir, as the leader of the policies in Parliament, and on behalf of the Speaker, all right, that this process will go as prescribed in law and procedure, and under my watch, that the right things will be done. I will give you that assurance, and I want this public, of course, for the MPs, we are part of the process, but I want the public to give that trust that this process will go and it will be peaceful in this Parliament. I want to give you that assurance. I'm giving you that assurance. This process, even this morning as we are seated here, the two leaders is with their approval. Leaders, sir, please, just your attention. All right, no, I have to go right, sir.
We have to talk this one.
All right. For us to have a privilege today, the two of them agreed, and Mr. Speaker agreed. I only directed the AG that he has to be here today to do his presentation. All right. After first reading. No, that's I'm talking. Well, we are still talking. He's on it. All right, sir. All right. AG, you are reminded. AG,
He's not listening.
AG, you are reminded the last discussion we had before coming here. All right.
No, sir, it's not properly before us.
No, sir. Let's not take that link, sir. Thank you, sir. So the assurance is to you, the public, those that are not members of Parliament. All right, that even for the privilege to be held today, the two of them agreed. All right, that is how open and participatory it has been, and that is the way it will remain. The reason why we have not slated date for the second reading, I had a discussion with him. We've not been able to have a clear-cut timetable. I'm bringing up that to show the level of transparency that has been. All right. It's because I discussed with him and he could not give me any clear-cut timetable for the APC's lower level election because he want their members to be fully participatory. All right, so I have discussed with Mr. Speaker. I'm explaining to the general public, not necessarily you to MPs because you are aware. So what we did was to do the first reading and to leave the second reading a little bit relaxed. One, the public will be able to make their input, and at the same time, as they give us their timeline, we'll be able to slate when we'll be having our second reading, which is actually the most important thing. No, he hasn't been able to give me a clear timeline. All right. So why I'm explaining this, and for the general public, for all those that will be going over radio, being constitutional experts, please do this clerk a favor. Put it in writing in a position. People have received something like 3 or 4. I'll be reacting to them. I'll be writing a special letter of thank you to thank them that they've put their opinions on paper and we appreciate it. And I'm going to get all of those documents photocopy, 2 copies or perhaps 4 copies, 1 set for the 2 leaders, 1 for the chairperson and another that I will keep with myself. And I'm also promised the legislative chair this morning, I'm going to make a summary of those key recommendations so that it will ease his own work and get it across to him. But if you are also a member of the public and you want to make input, but you cannot read and write, I'll be announcing that our media team will be out, gets to them, they will sit down with you, you explain your story, and they will write it down. And it will be part of the process. We will not be having time to be listening to every conversation that you'll be doing on the radio or on the television. Our media team will attend, but we are going to make this as open and transparent. The reason why I read a portion of the standing orders this morning, SO 47-2, all right, because they've taken out their time from their busy schedules to be part of this process. It would have been unfair for them to come. Some of them might want to make statements and they are not giving a platform for them to make statements, but you know it's a name. It is not mandatory. So I'm leaving that to the chair and the AG's office to say, okay, we want to, apart from honorable members, we want to hear this person, we want to hear this person. But this is the assurance. This process is going through as prescribed in the Constitution and the standing orders. All right? After the second reading, it will be committed to the legislative committee wherein, or maybe they will decide they want to get a committee of the whole house. If there are any amendments, like for instance, reference to trench and entrenched clauses included, you can just expunge it at committee stage. Heaven and hell is not going to come down. The sky is still going to remain up, and this constitution will go through. But I will assure you, it will be peaceful and it will go according to procedure. Thank you.
Thank you very much, Mr. Brown. Thank you very much, leader of the opposition, for reminding us about some of the laws surrounding this process. And also thank you very much, Mr. Clark, for the assurance that Parliament will adhere to the rules or the laws surrounding this whole process. If I'm to re-echo the remarks of the leader of the opposition, this is a defining moment in our history. We consider ourselves very lucky to be part of this process. You don't review or amend the constitution on a daily basis. But the big question is, how do you want to be remembered in this process? It is not an APC constitution or an SLPP constitution. It's the constitution of Sierra Leone. So I want to encourage each and every one of us to keep an open mind when we approach this process. It's very important. We are setting the stage now for an inclusive society and pave the way for the new generation of game changers. So I want to encourage all of us to keep it in the manner we're trying to do right now. And I strongly believe by the end of the day, our representation will re-echo the thoughts of our people. Thank you very much again, leader of the opposition. I'll now call on the leader of government business, Honorable Matthew Samuma from Bukakajama and Bulamayama. I hope the people from Bukakajama and Bulamayama are watching this program.
I don't know. We are very exit-savvy. We are modern people of Bukakajama and Bulamayama. My constituents are so entrenched in following what we are doing in Spanish Parliament. Chairman, with your leave, my counterpart, wanted to talk about the cartoon and the animal. I was carefully listening when he said anything different from not putting us together, we just recuse ourselves. I agree with you, sir. With your leave, sir, I want to take the opportunity to thank you for your speech and salute you for being cooperative in working for the progress of this country. Let me start on existing protocols by singling out my former colleague, a brother, and a comrade. A comrade with 2 pens. One is black and the other one is red. So I have to take one. From that, I follow the existing protocols. Mr. Chairman, we are on record from the 5th Parliament to the 6th Parliament for progressive laws. We are not on records for abrogating the rules of procedure. We are not. I have evidences to the effect. Laws that have passed to the people of love unities all over the country, beyond Sierra Leone. I engage my previous counterpart, Honorable Chairman Manuel, in succeeding in passing most of those difficult legislations, because we believe that Sierra Leone is for all of us. Our similarities are far greater than our differences. And Sierra Leone is the only hope for the country we can do the things that we believe in, to have progressive laws that we can transform the trajectory of this country. When we started the repeal of Part 5 of the Public Order Act, people said we are not going to do it. We don't mean it. We succeeded in repealing it. Some people ambassaded us, but today we are praised right across it at the international platform that we did the bullet laws, we ratified, we repealed Part 5 of the Public Order Act, the obnoxious laws. We are able to do so because we put Sierra Leone first. At that moment, people are against, some people are for. Not everybody will follow us. We have our differences, but we should be futuristic. we are willing to take this country. That is why all of us are here today. We have decided to form this gathering using Section 47 as stated by the Clerk of Parliament. He has elucidated clearly on those points, understanding others. That we need the stakeholders engagement. It's time to new. The Sexual Offences Act, we started with that as a progressive law under the administration of the opposition, Chairman Majuba. We have people coming. If at the last minute we wanted to pass the law, they said they have their opinions, they have something to input. We looked at it, it was important, and that was included. And you see, it's part of that law. But there are things that we still need to do. The Sexual Offences Act. We did agree on at administrative levels to have the forensic testing, so we can have proper evidence in terms of prosecution. So we can have ourselves clear in mind what we are going to do. Yes, we are still on that trajectory to have funding for us to do forensic tests when it comes to investigating sexual offences issues. Mr. Chairman, I know that a few of those things have done. We came down to the Give Act. Then the women have love unity all over the place. They came, these are proposals. This was the proposal. Even if they are put in an entrenched clause, when we go to the chamber, we just remove. We know the rules of procedure. This is a government motion. It's a proposal from the minister. We can even decide not to even consider any of these clauses and stay where we are. Because we are progressive, we are open-minded people. We have allowed the public using 47, understand the others, to make sure that we discuss this being in the interest of Sierra Leone. Another point, when they give the act, when they give the BK, there was no provision for women's empowerment. There was no provision. Like we did for the repeal, we had to amend the INC law. The act was amended to accommodate some of the things that you are going to come with. If you repeal, what will be the other laws that you depend on if your civil liberty is abused? We don't want people to say, oh, there is lacuna, we have done this. What about other citizens who are exposed to these people? We have to be professional journalists. We came into this hall, we have some buha between one stakeholder and the chair. Yeah, that is natural. We settled it. But we did not take our eyes off the ball. We succeeded in having a reformed IMC Act that accommodates everybody and also the repeal. In the Give Act we have today, there's no provision to empower women. There's no provision to empower women. We did that principally because you can't be one to empower women and you deviated completely for what you proposed to us. Thank you. So that's what we have. But there are more to it, which are yet to accept. We came with a PPLC Act. We have done some constitutional amendments. And today PPLC is active. Thank you, Mr. Chairman, for putting us on the right track. Finding both political parties trying to exchange words of violence. What we need to succeed to do is to finance smaller parties. You cannot get all. But we are able to come to terms with the opposition, with the paramount chiefs, to see we can be EP and C. Where we are today, we have both former AGs with us. They are sitting together, Gerard and MLT Momelani. Thank you very much for your contribution in having this document in front of you. Thank you. Coming to the Public Elections Act, because this ball we have reforms in this constitutional process we have. They came with 30% quota. We are struggling with it. In fact, me and the then Bishop leader, Honorable General Baduba, people are calling us, lambasting us, trying to be very selfish in our thinking, and we are not nationalistic, we are not patriotic when we are about to do the public elections at 2022. We are only for 2 months. They called me. I cannot say the words that they told me exactly. But I used their form of abusive language to me to educate them. I was able to convert some to understand what you are doing. Some you cannot change them. The Romans say you don't change, you don't give new meaning to hold up. But I use that platform to change most of them. And they are my friends to you. In that act, people are lambasting us. They are malicious. I told my counterpart, look, the fear of accident cannot stop us from driving. They came with 30% quota. I said, why do you want to give women 30%? The messenger was the problem. Everybody was coming in position, paper, wages. And we discussed that there's a way we can do it. Section 58 of the Public Elections Act. We wanted to have women representation directly elected to parliament and local councils over 30% or beyond. So we took 2 positions into consideration. One is to have the women directly elected with over 30%, both at parliamentary level and local councils. And that one was also we did not ask the president because of executive power, which we cannot take from him, but to encourage him in the Giwi Act to consider giving women 30% quota at the minimum rate for positions coming from the executive. That's what we are seeing today working. It is working. And when we use the section 58 of the public election of 2022, Parliament, directly elected members of Parliament, we have over 30%. We got that one right. Councils, we have 30%. We got that one right. So it's a proposal like this nature. We need to open our minds. We need to come with contributions so that we can change the trajectory of our political thinking. Let us think for the interest of Sierra Leone, not for ourselves. Let us be clear on it. For me, I have read this document over and over. I can even quote pages as I sit here. I have played with it. But I'm very happy for us to have it. I like controversial issues. It makes me stronger. But let me assure you, there is no other hand game in this business. This is part of what we are doing. We have done consultations at different levels. This is purely for members of parliament to understand the trajectory we are taking for the particular law to be enacted. This is a transformative drive. It's not in the interest of President Bio. It's not in the interest of the opposition. It's not in the interest of SFP, PDP, etc. But purely in the interest to salvage our democracy. It's the interest to salvage the common man and woman in Sierra Leone. It is a move to transform our election systems. We have all gone through turbulent times. The only thing that is dividing us as a country is politics. It's politics. And we, some of us, we are using these reforms to change our thinking about how we handle politics in this country. That is why nobody can defeat me for my friendship and my brotherhood General Maduba, the APC and SFP. It has nothing to do with our political thoughts. That's why I was able to use my friendship as a brother to look at Sierra Leone to do the reforms. Likewise, I'm doing with my honorable member, Abu Kabu. A comrade and a brother. Yes. We cannot allow those who are thinking selfishly to drive us to a crazy debate. But we can shape the lives of our people who we represent effectively here by doing the right thing. Open consultations. Let me assure you, this is not new. This is not the end. As the clerk said, we are going to have continuous deliberation on these things with the stakeholders. You have your positions. Bring your position to the class of parliament. We can deliberate on them. We come to legislative after the debate. We come back to see to look at clause after clause, and we go back to debate some of these clauses. We know the rules of procedure in enacting constitutional instruments. We know very well. We cannot surrogate that one for anything. But let me assure you that we are being a very progressive parliament and will continue to do so. And as parliament, we don't live because we are APC, SLPP, and the paramount chiefs. We are family here. I'm fully aware that the public don't like parliament, but they would like to use the parliament to divide us, to split chaos. We cannot allow that one. I will bend backwards. If it costs us 100 times, the SLPPs and the APs and the paramount chiefs to continue to deliberate on this document, to have a consensus document so we can stand, so that it can benefit Sierra Leone, not any single political party. We are doing this in the interest of Sierra Leone. So those who have listened for a lot of social media discussions, we are starting somewhere. We have had white papers from APC and SLPP. We are still moving. We are not going to throw them under the table. We look at them one after the other. Those are supposed to go for referendum. The AG and the government, they will take care of that one. If it comes to us, we'll follow the proper rules of procedure. So that's the assurance I'm giving you. Like this is not the end today. Even if you are not given the opportunity to talk here today or to make your contributions, you have a bigger platform to write for us. Let us make our position nationalistic. Not because we are looking at this, now I go benefit APC, I go benefit SLPP. Don't look at that way. If you come to me with that argument, you will not succeed. Because I will not listen. So I thank you very much for coming. I thank you for your contributions, especially for AG. You have been very magnanimous in dealing with this document. It's not easy to have it. As I said, the public don't like parliament. That is clear. Because when we are talking about our welfare, the stakeholders will go after us. If you are talking about city fees, they will forget about this document and go after us. We talk about medical, they will like to follow my MPs. But you don't have a vote. Not even taking consideration the MP is sick, is going abroad. But what matters for us, not how you feel about us, not what you say about us, but the intrinsic value in us, representing our people with honesty, with fairness, and diligence. We will continue to serve this nation, irrespective of the innuendos as passions at this parliament. We will stand tall to do progressive law. We will stand tall to unite this nation. Not by rhetoric, but by the rule of law. Thank you very much for coming. The Lord bless us all.
Thank you very much, leader of government business. It's clear from your remarks that strong leadership is critical for constitutional review process, especially when you have to navigate complex political transition and also to ensure that the resulting document from this exercise has the legitimacy it deserves. I think a well-led, transparent and inclusive process will ensure that kind of public ownership we want for this. And I strongly believe that we are going to achieve that. Again, it's an issue of active participation and total involvement of each and every one of us. Sierra Leone is the bigger picture. Let's remember that. Thank you very much again, leader of government business. I'll now call the Attorney General and Minister of Justice for his remarks. Mr. Alpha Sise Esquire.
Thank you. To the leader of government business, Honorable Matthew Sanyuma, leader of the opposition in parliament, Honorable Abdul Kabu, I must say both of whom are also my comrades of the Almighty Radicals Club. Yes, well, I mean, the leader of the opposition is Nigerian. But of course, you know, there are very senior comrades of the Radicals Club seated to my right, former dictator of the Radicals Club, Joseph Fitzgerald Kamara, JFK senior comrade,
Yes, our radical business.
Cheroma Juba, former deputy speaker of parliament, and then of course, my elder brother and predecessor, former Attorney General Mohammed Lamin Tarawali. So this to say that outside APC and SLPP circles, we still meet in other places to discuss moving this country forward. And also to, of course, you know, the chair of the commissioner of the PPRC, former dictator Kuriba Amara, also a comrade. So it's a big family. And then, of course, the clerk of parliament, you know, Mr. Kamwakonze, also a comrade. So there are others seated. And of course, the Minister of Information and Civic Education, also a comrade. So it's a big family. It's a big family. Well, he's my junior comrade. But also to acknowledge the Deputy Leader 1 and Deputy Leader 2 of Government Business, the Deputy Speaker of Parliament, the Chair of the Legislative Committee of Parliament, the former Speaker of the ECOWAS Parliament, Honorable Members of Parliament, Ministers and Deputy Ministers, Her Worship, the Mayor of Freetown City Council, as civil society partners who have also been crucial to this process, development partners, ladies and gentlemen, good afternoon. Thanks to the leadership of Parliament for the opportunity to do this presentation here today. I'd like to say that this is part of doing the people's work. Mr. Chair, we are glad that this bill before you has generated significant public interest. When we decided to move beyond the traditional means of gazetting bills in Sierra Leone by posting an electric version of this bill to the public, this is exactly what we anticipated: public interest, public discourse, and public feedback. We are glad to have accomplished that. For us as government, we do not want these public engagements to end with the pre-legislative hearing we have today. We want this to be the beginning. We want these discussions to move into the days and weeks ahead as we strive to produce a constitution that will work for the people of this country. In the days and weeks ahead, we look forward to having constructive discussions with various groups, with our civil society partners, political parties, women's groups, youth groups, our development partners, other marginalized groups, including persons with disabilities, and with the broader Sierra Leone public. This is because this is just a bill. It is not meant to be the final document that becomes law. It is meant to lay the foundation for broader public discourse and feedback. And that is what we will do with this process. As a people, Mr. Chair, we should embrace this moment as a historic opportunity for democratic renewal in our country. Our country is embarking on several reforms that will inform the nature and character of our governance system for decades. We are in the middle of major electoral reforms at a time when we are trying to conclude a long-standing constitutional review process. These are major undertakings that we must all embrace and accompany to completion. I like to say that, like a running train on a track, these reforms must go hand in hand. His Excellency President Julius Maada Bio remains steadfast in his commitment to conclude our nation's constitutional review process, a journey spanning over 2 decades. This is not merely about legal reform. It is about strengthening the bedrock of our democracy. The President has made it clear. Finalizing this process is central to our governance agenda, alongside transformative reforms in the public sector and other pillars of the Big Five game changers. The reforms we discuss in this bill come as a result of our acknowledgement of the challenges we have faced in our electoral and governance architecture. While we acknowledge these challenges, we must also note that as a nation, we stand on the shoulders of a remarkable democratic journey, one forged in the fires of adversity and sustained by our unyielding commitment to peace. Since emerging from the darkness of civil war, Sierra Leone has held 5 consecutive democratic elections, each a milestone in our collective journey. Among these, 2 historic transfers of power to the opposition in 2007 and 2018. These stand as towering achievements that we should celebrate. But these were not merely political events, they were triumphs of national character, proving that our democracy is not just functional, but it's maturing. For a country that went through decades of one-party dictatorship, subjected to military coups brought to its lowest ebb as a result of civil war, the journey we have walked to this point, though not perfect, is one that we must celebrate. Yet, let us be candid that no democracy is without its trials. We have navigated several challenges as a nation. We've had to deal with election disputes, we've had to deal with institutional gaps, and yes, we have had to deal with moments of polarization. But the truth we must cling to is this: and these challenges are not indictments of failure. They are the necessary growing pains of a democracy finding its footing. They remind us that democracy is not a destination, but a continuous act of collective will and refinement. This is precisely why in this process of constitutional making, we have adopted one irreducible principle: listening. Listen not just to the powerful, but to the market woman in Waterloo who fears that her vote doesn't count. To the youth activist in Go, who is demanding a seat at the table. To the traditional leader in Kono, who is bridging old traditions and new aspirations. And to the young girl in Makeni, yearning for fairness and equity in decision making. Their voices, your voices, did not just inform the process, they drove the process. The national conversation we have now was born from this very ethos that electoral systems must serve people, not power. Today, we confront a pivotal choice. Will we settle for systems that merely function, or will we demand systems that inspire trust, amplify voices, and endure? It is my hope, and truly the hope of His Excellency the President, that we will opt for the latter. Mr. Chairman, kindly allow me to walk us through the journey we have walked as a nation to get to this point. I'm very pleased that 2 of my predecessors are seated here today, and we have asked the 2 of them to be together because they have been very integral to this process. They have both been shepherds of the long-standing constitutional review process. They have both managed white papers in 2017 and 2021. And I'm referring to the attorneys general before me, Joseph Fitzgerald Kamara, commonly known as JFK, former Attorney General and Minister of Justice, and flag bearer aspirant for the All People's Congress Party, and Mohammed Lamin Tarawali Esquire, former Attorney General and Minister of Justice. Both, as I said earlier on, are very senior Congress of the West as well. This nation owes the 2 of you a debt of gratitude for the way you have managed this process, and it has been an incredible honor to continue to learn from you. to be inspired by the work that you do, and that you have remained committed to work with us to take this work to completion. There are others who worked on this process who are not here today, originally started by former Attorney General, the late Solomon Ekumaberewa, and then moving on to other holders of this office. May their souls rest in perfect peace. I also want to pay special tribute to the Deputy Minister of Justice, Madam Saptiu Sako, whose commitment to make sure that we have a gender-responsive constitution has been inspiring. In the weeks ahead, the Deputy Minister of Justice and I both intend to have detailed engagement with women's groups to make sure that this constitution works for women of Sierra Leone. I also want to pay tribute to two persons who have been integral to this process, I would say, who are authors of a significant part of the bill that we have before us. The co-chairs of the tripartite process, Dr. Emmanuel Gaima, who represented the government of Sierra Leone, his co-chair, and Dr. Kelfana Mara, who represented the All People's Congress in the tripartite process. I say this to let you know that the bill we have before us has two major sources. One, the Kawan constitutional review process managed by two ages before me, and the tripartite process managed by the two co-chairs I have just mentioned. There is nothing else that government has added to this bill outside these two processes. I think I have been very public to say yes, there are one or two provisions that have been amended, which is really what governments do, right? With white papers, you accept, you reject, or you accept with modifications. We've been very public about these, and these will also form the basis of discussions that we will have in the weeks ahead. And credit also goes to our civil society and development partners who have continued to support this process. Your input has been crucial, and we look forward to continued engagement with you on this. I'd like to say that at a time when people are quick to talk about polarization in governance, when people are quick to talk about the things that we disagree on, when people are quick to point to the fact that one government says one thing and then a political party opposes because of the messenger, I like to say that the constitutional review process is one thing that we all agree on. Because every government, since the war came to an end, has worked diligently to take this process to completion. From the government of late President Kaba to that of former President Nkrumah, and then now President Bio. So really, this is an example of continuity in government, and so we must embrace it. So, Mr. Chair, kindly allow me to provide some historical context. The constitutional review process itself.
You want to start your presentation now for him?
No. I'll come to the presentation. The constitutional review process, as we know it, is a product first of the Leone Peace Agreement in 1999. Because in Leone, we agreed that the 1991 Constitution as framed was not sufficient to prevent a backsliding. And so we continued this in the work of the Truth and Reconciliation Commission. And so this became a crucial recommendation in the report of the Truth and Reconciliation Commission, the mechanism set up following the end of the conflict in 2002. And so the process was first started by late President Ahmad Tijan Kaba in 2007 and was subsequently picked up by former President Ernest Bai Koroma, who constituted the Justice Edmund Cowan Constitutional Review Committee. And I'd like to note that as we hold these discussions here today, we do so during the very week, 2 days ago from today, that the architect of this process, the late Justice Cowan, departed this world for the world beyond. And so with your leave, Mr. Chair, I would want to call on this gathering to observe a moment of silence for him. May his soul and the souls of the faithfully departed rest in peace. So, as I just stated, the Constitutional Review Committee, set up by former President Ernest Bai Koroma and chaired by the late Justice Edmund Cowan, had 80 members from all shades of life: political parties, civil society, youth groups, women's groups, journalists, etc., etc. The committee itself operated from 2013 to 2017 with technical and financial support from UNDP, UN Women, United Kingdom, European Union, and then the Ministries of Foreign Affairs of Kenya and Ghana. So really the process has been as participatory and as inclusive as possible, and has been done in the national interest. The figures are there to speak to it. The 80-member Justice Edmund Cowan Constitutional Review Committee held over 10,000 public consultations with various stakeholders nationwide, over 10,000. Had 133 stakeholder engagements with women, youth, political parties, paramount chiefs, local councillors, CSOs, media, lawyers, etc. Consulted with 198 MDAs, commissions, religious groups, and other institutions. Had 80 expert engagements on key constitutional issues. Received over 150 position papers from political parties, MDAs, and various groups. Had over 20,000 hours of airtime over the media, including live debates, jingles, theme songs, etc. Distributed over 70,000 forms for people to answer questions and provide responses to key constitutional issues, or really lay out their own views or aspirations for what a revised or a new constitution should look like. It operated a website that received 40,960 visitors, had a Facebook page that had over 12,000 followers. When you consider internet penetration going years back, I think those numbers are telling. So the Cowan Constitutional Review Committee handed its report to former President Koroma in January 2017, and in June 2017, the government of former President Ernest Bai Koroma issued a white paper in which it accepted some recommendations and rejected some. And then there was a transition in government. Following his election in 2018, His Excellency President Julius Maada Bio decided to pick up the process from where it was left in 2017, after Justice Cowan submitted a committee's report to former President Koroma. And in March 2021, the government of His Excellency President Bio issued a second white paper on the Justice Edmund Cowan Constitutional Review Committee report. The white paper reflects the contributions, aspirations, and determination of the people of Sierra Leone to improve and sustain the rule of law, lasting peace, and human development. Recently, a few months ago, when I had a discussion with the National Women's Conference, their memo indicated that they had identified 16 issues in the Cowan report which were of importance to women. And they were pleased that government had accepted 12 of those 16 recommendations as issues that are important to the women of this country. At the meeting, I made clear to them that in fact government had acted on the remaining 4. So you can see that in the significant way has also influenced the process. During the Universal Periodic Review in May 2021, Sierra Leone made a pledge that will conclude the constitutional review process, and that is what we are working on. Of course, in the middle of this, we had the tripartite process that I mentioned earlier. A process that came as a result of our disagreement over the outcome of the 2023 elections. And together with our brothers and sisters in the APC, we sat down for 6 months, engaged various interest groups, including electoral management bodies, civil society, other political parties, and under the leadership of Dr. Gaima and Dr. Mara, we moved across this country to gather the views of Sierra Leoneans. The 80 recommendations we agreed on in the tripartite report are the product of this national exercise. And some of these recommendations touch on constitutional amendments. As a government, we agreed that these will be added to the recommendations in the Justice Edmund Cowan Constitutional Review Committee report. And this is what we have in this bill. If anyone tells you that the provisions in this bill are the creation of government alone, they have lied to you. The provisions in this bill are exclusively the product of the Justice Cowan Constitutional Review Committee report set up by former President Nkrumah and that of the tripartite report and its recommendations co-chaired by Dr. Gaima and Dr. Mara. Government has not added anything, but I've been very public to state that yes, there are 1 or 2 provisions that government has amended, which is the right thing to do, but they are not set in stone. That is the essence of these engagements, the essence of these consultations. And then, of course, at the end of this exercise, Parliament will determine what will go into the Constitution. So I like to say that we have not done this in hiding, but to also say that a lot of people trying to get political mileage on this bill have received its content since last year. The contents of this bill are not new to many of the stakeholders who are not speaking about it. This has been in the custody of several of the people who now speak publicly about provisions in this bill. And these are discussions we could have had even before getting to this stage. So I think let's approach this with the honesty it deserves. Among several consultations, the last set of public consultations, and that's not to count the ones that have happened in my office. On the 28th of October last year, we had consultations that were public with electoral management bodies. On the 30th of October, we have consultations with political parties on the legislative proposals. And there were other such consultations before now. As a matter of fact, I think my brother and comrade, the leader of the opposition in parliament, in fact represented the APC in the last consultation that we had on the 30th of October. And then we have had the same with civil society organizations and the media sector. We had such a meeting on the 31st. These are additions to the ones we had before now, and the engagements we have had across the country, and engagements that have happened in my office, during which we have been very open and have shared the presentation that I'll make here today. I also mentioned that we have had discussions with women groups where we assured them that the 16 recommendations in the Women's Manifesto will be part of the new constitution. But I'd like to emphasize, Mr. Chair, honorable members of parliament, ladies and gentlemen, that these consultations have not come to an end. They must continue in the days and weeks as we strive to make this a better document that will work for Sierra Leone. Of course, persons who have been part of this process, should continue to engage and make this better. But to refuse to take ownership for what we have done together, and then to oppose this just because it is led by government or to build political mileage, it's not leadership. To mislead the people we seek to govern for political mileage is not leadership. So as we take this process to a conclusion, Mr. Chair, ladies and gentlemen, let us be guided by certain things. Let us note that Sierra Leone has transformed significantly in recent decades. Our demographics, our economy, and our social dynamics have all evolved. Therefore, our constitution must keep pace with these changes. A new constitution will better capture the realities and aspirations of our people, ensuring that our governance structures and legal provisions are fit for today's Sierra Leone and the future we envision. Revising our outdated sections ensures our legal framework is robust and relevant, is capable of addressing modern challenges and fostering a just society. We pride ourselves in being a tolerant nation that puts national unity over ethnicity, over religion, and over political affiliations. This is another chance for us to show that unity. Mr. Speaker, I want to conclude by saying that this should not and will not be a rushed process. Constitutions are meant to outlive us, and they must reflect the views and aspirations of the people of Sierra Leone. The Constitution must be owned by them. We acknowledge that no bill is perfect. That is why it is called a bill. It is our hope that the legislation that comes out of this process will be better than the bill that we discussed today and in the weeks to come. On that note, thank you, Mr. Chairman, and I'd like to transition to going through specific proposals that are in this bill, with your leave.
Thank you, Mr. Thank you, Mr. And I want to thank you for giving us an in-depth view of this constitutional review journey. And in your remarks, you've clearly reminded us that this is a product of the Justice Cowan White Paper, the tripartite agreement, and of course, consultative engagements around the country. So it is a document for Sierra Leoneans. And I think as a parliament, it's also our responsibility to ensure that we come out with a document that will meet the expectations of Sierra Leoneans. What type of document is that? A document that will help us to sustain the peace we build. A document that will help us build national cohesion. a document that will help us maintain the rule of law, a document that will help promote human development. So, Mr. AG, the document is now in the hands of Parliament, but it's good to remind us that the discussion will continue. As representatives of the people, we're open to all suggestions, position papers that will come from the public, to ensure that we incorporate them into this document and that we reflect their voices. So I think now we are going to proceed to the presentation proper. We're going to look at, I don't know the method you're going to use, but maybe provision after provision. And then members will have the opportunity to ask questions and maybe offer suggestions. And then, of course, maybe seek clarification where necessary. So, AG, the floor is yours for the presentation. Thank you very much.
Sure.
Thank you.
This camera is for good handle.
Thank you, Chair,
But you can't be
and leadership of Parliament. So, what I'm going to do is to go through a PowerPoint presentation of the provisions in the bill. And I'll provide context to some, and where possible, I'm able to see what is from the current process or from the tripartite process, and then of course leave it up for questions. First is to say what we try to do with this process. After the tripartite report was submitted to His Excellency the President, 80 recommendations agreed to. We took out the recommendations that touch on constitutional amendments. But then we have always been very clear of that the broader constitutional review process is a subject of a long-standing government commitment. And of course, as I just mentioned, going back to the days of the late President Kaba and continuing to this point. So I like to say that really we've been running a relay. Wherein one government has been handing this baton to another government. The only thing is that the current government has made a commitment that we will not transition this baton to another government. So what we did was to put, first let me say, yes, subject of long-standing commitment by government. And so we've always been very clear that the tripartite process, as important as it is, was never meant to undo existing government commitment to broader reforms, including the constitutional review process. It was meant to complement existing or ongoing reforms being managed by government. And so when we took out the recommendations that touch on constitutional amendments and paired them with the recommendations that have been made by the Cowan Constitutional Review Committee, we were fortunate to find out that a lot of the proposals really align. They speak to each other. They do not contradict each other. But then there were proposals made by the tripartite committee which were not in the Cowan report, but also some proposals made by the Cowan report which had not been captured by the tripartite process. But they really did not contradict each other. And so what we did was to prepare a document that laid out how these proposals speak to each other, which one comes from tripartite or from Kawan, and put them in a document that, again, since last year, has been shared with several stakeholders in this room. So that's just to say that is how we choose to approach it. But again, like I said, this is part of broader efforts to conclude the constitutional review process. So we note that that process cannot be completed in January or in February. And so what we agreed on with all stakeholders, what we agreed on was that because elections are time sensitive, you do not want to undertake electoral reforms, or you do not want to amend provisions that touch on the conduct of elections close to elections. We agreed, all of us who have been part of this process, to take out the constitutional proposals that touch on elections and bring them to Parliament as a separate bill. We have laid this out as the procedure that will follow. That is also because there are other reforms taking place, right? We have subjected the Electoral Commission for Sierra Leone to a functional management review, and then we are in discussions based on recommendations in the tripartite process, as well as consultations with a broader set of stakeholders that we will review the relevant laws that touch on elections, Public Elections Act, the Political Parties Act, etc. And so to do all of those reviews, it is important to take the amendments that touch on elections to completion, so that these, once they go through Parliament, will speak to the reforms that get into the various pieces of legislation on the conduct of elections. But then, once we're done with these, we'll now continue with the broader constitutional review process. But then we'll have taken the elections proposals out of the way. This is not something that became public overnight. This is something that we have discussed. And matter of fact, lots of people, including persons in this room, asked questions of me up to last year as to why this bill was not in Parliament last year. But then we said, in fact, we called for the last set of consultations in October, just to inform this process. And then we said technical details. We had to put Mr. Thompson, our draftsman, under immense pressure to get this bill together. But then now it's here. Some people have again said that it is rushed, including those who were urging me to bring this to Parliament last year.
AG, so just sorry for the interruption. Can we please make yes, when we go clause by clause, we also have the opportunity to go in from any clause.
Yeah, thank you for that, Chair. I really just wanted to know why we have the constitutional amendments on elections and how we transition to the broader constitutional review after this. So please let's go to the first slide. So one, it is recommended that the Electoral Commission be renamed to National Electoral Commission for Sierra Leone. We are all used to calling it NEC. And so it is proposed, not by government,
For the news we dey around, log into Liberty TV online. Positively we bring the change. They get the masses involved, staffs them everywhere, everywhere. We climb the mountain just to get the news. We go down the slums to get the views. Hi yeah, hey, voices come. Credibility, now we ability. News, give the views, the tell where you want them. Government issues, them focus, now we not the answer. We human them, girl picking, that's a get the power. He count on me, he count on we anyhow. Give the news, give the views, the tell where you want them. Government issues, them focus, now we not the answer. Human them, girl begin the security power. If you call on me, count on me anyhow. Liberty we ride, like a nigga we fly. Liberty TV day before. We climb the mountain just to get the news. Go down the slums to get the views. Hi yeah, voices down. Hi yeah, give the news, give the views, the tell where you want them. Government issues, them focus, now we not the answer. We human them, girl picking, that's a get the power. He count on me, he count on we anyhow. Give the news, give the view, the tell where you want them. Government issues, them focus, now we not the answer. We human them, girl begin, let's get the power. We keep calling me, count on me anyhow. We speak free and fearless, inclusive journalism. Speak free and fearless, inclusive journalism. For the news we dey around, log into Liberty TV online. Positively we bring the change. They get the masses involved, staffs them everywhere, everywhere. We climb the mountain just to get the news. We go down the slums to get the views. Hi yeah, hey, voices come. Hi yeah, credibility, now we ability. News, give the views, the tell where you want them. Government issues, them focus, now we not the answer. We human them, girl picking, that's a get the power. He count on me, he count on we anyhow. Give the news, give the views, the tell where you want them. Government issues, them focus, now we not the answer. Human them, girl begin the security power. If you call on me, count on me anyhow. Liberty we ride, like a nigga we fly. Liberty TV day before. We climb the mountain just to get the news. Go down the slums to get the views. Hi yeah, voices down. Hi yeah, give the news, give the views, the tell where you want them.
And we'll work with members of parliament we're very open. If they're on the need for a transitional clause for this particular provision, we're very open to that. It's something that we support. I think we'll be very public about that. And then, of course, these are the technical details of that amendment. It is also proposed that sections 41 and 42 of the Constitution be amended to remove the requirement for political party nomination, to facilitate independent candidature for the presidency. We know it's a thorny issue, but we also note that it was a recommendation made in the Kawan report. It was a recommendation made by the Tripartite Committee, and also it's reflected in the one of 16 recommendations made in the Women's Manifesto. Of course,
Other honorable members, please.
of course,
Thank you very much.
Of course, we have also said in the bill that yes, the concern that this might open the floodgates, and then you have a lot of independent candidates, which will make the process hard to manage, is a legitimate concern. And so that is why in the bill that we have here, we have put in certain conditions. One, of course, we do not want someone losing flag bearership elections in a particular political party and then overnight just transitions to being an independent candidate. So yes, I think with members of parliament will have to put a clause on. We have said that the person should not be a member of a political party, but I think timing on that will be good to do. We have also said that the person must demonstrate sufficient financial and community support. Community support, and as prescribed by law, that will be prescribed in a separate law by parliament. And community support we do like you have in certain countries, verifiable registered voters to sign up and take a bet on that candidate. And then we have said financial standing as well, to be determined by parliament to see. But we also note that really listening to public discussions or engage with various stakeholders, a financial requirement will eliminate very good and credible persons from the presidency, including women who should be able to participate in this process without these extra roadblocks being created. And that is why, in fact, one of the proposals we have in other legislation is really the removal or reduction of candidacy fees for women, and then of course other for marginalized groups. But yes, that is a provision that we want to have a discussion on and come up with something that will work for the people of this country. So yes, that will. And then we come to section 42.2. Our current system requires a candidate to put 55% of votes in the first round. Then, of course, we've had to deal with the challenges of runoff elections. In fact, someone brought to my attention that the runoff elections sometimes are even more problematic than those on the first round of elections. And so, in the constitutional review process, before the tripartite process, yes, it is reflected in the white paper that will move from the 55% threshold. And then, in the tripartite report, it was also recommended that we move from the 55% threshold. Now, when I talk about areas where both processes align, This is really one such area that we move from 55% threshold. Now the debate has actually been whether it's 50 plus 1 or a simple majority. Say, right? So that has been the question. But then there is also the threshold. Because when we discussed this on the tripartite committee, we talked about moving from the 55% threshold, but I think we also discussed the need to keep this country together. And so that is why the tripartite report recommended that yes, you move from 55%, but you also have the threshold system. And yes, tripartite recommended that the candidate must also pull at least 25% of total valid votes cast in half of the voting districts. I think I've been very public to say that is what tripartite recommended. So 16 districts, that would be 8. But then when we discussed this, and again, this is not a surprise because, I have raised this repeatedly, that we have discussed this in government, with all stakeholders, saying half of the voting district doesn't really solve the problem. Because a candidate and political party will focus on their own stronghold and run the numbers there, which is what we really don't want. That's the problem that we're trying to solve. When we came up with the 25% threshold in half of the voting district, we realized that half doesn't solve the problem. And so our proposal, it's a proposal, I must emphasize. Our proposal in this bill is that reduce from 25% to 20, but now in 2/3 of the voting districts. And so yes, we want our political parties to have national agendas. We want our political parties and candidates to have national appeals, to look beyond their strongholds. And that is why we reduce the threshold, but then broaden the scope of it to cover 2/3 of the voting districts instead of half of the voting districts. And then this, so the current law actually says 7 days, right? So the tripartite committee recommended that where there is an election dispute, in an election where no candidate has met the threshold under section 42, that's to mean for an election that is meant to go into a runoff, then petitions should be filed within 3 days. If it's an election that will not go into a runoff, then the 7-day window prescribed by law actually is what applies. So this window applies only to an election that will go into a runoff, where a candidate has not met the threshold under section 42 of the Constitution. And then, really, we have had to deal with cases where the election petitions take forever to determine, to adjudicate. Right? It's a complaint that we have filed, we have all made. And so, the proposal from the tripartite committee was that the matter must be heard and determined within 14 days. Now, of course, under the leadership of the two gentlemen I mentioned here, we did not just come up with these numbers. We actually also had a session with the judiciary on this to discuss what is feasible, and what will work in the interest of justice. And together, we arrived at these numbers. So they were not arbitrary, they were not the creation of the tripartite committee. But again, like I've said, these are proposals. I think let's all discuss, and then what comes out of Parliament should definitely be better than what we have put in the bill. And yes, this really lays out that yes, a person dissatisfied may file a petition within 3 days. And then once that is filed, the Chief Justice will notify the Commissioner, the Chief Electoral Commissioner. The Chief Justice is supposed to be representative of the court, and yes, I think at that level, in the context of elections, that's how correspondence should be exchanged in the office of the Chief Justice and that of the Chief Electoral Commissioner, not at the level of one judge informing other members of the Commissioner or the Master and Registrar. But the Chief Justice can give directives for that correspondence to be passed through the other administrative measures that are available within the judiciary. So, yes, if no petition is filed, runoff to be held within 14 days of the notification. If petition is filed, the Supreme Court determines that within 14 days, and then, of course, if upholds the declaration, subject of the petition, then runoff to be held within 14 days. But then, if the court opposes the declaration, but then if the court invalidates the election in totality, then a fresh election will be held within 60 days. And of course, we explained the runoff process here, candidate getting highest and second highest, where two candidates tie in the total number of votes, those two candidates will go to a runoff. But then if an election is nullified, and then the election should be reconducted within 60 days, then all persons who have participated in the first round of elections should be able to participate. That is only if there's a petition before a runoff and that election is invalidated. We have this again, amend section 43 and 87 of the Constitution to provide a fixed date for holding elections. Yes, we proposed second Saturday in November. It is to say, again, it is not set in stone, it is a proposal. We also acknowledge that prior processes, including the Cowan and the tripartite processes, recommended dates between March, April, and May. But yes, it is the proposal of government that the elections be held in November of every 5th year. Now, one thing that I would like to make clear is that we acknowledge that Section 87 and that of 85 are entrenched provisions in our Constitution. But then, as has been explained, when an entrenched provision is amended, it has to go into a referendum. Now, in the public discourse that we have followed, some have said that we have skipped the referendum and brought a bill to Parliament. Actually, we are still on track. This is the procedure. You bring the bill to Parliament. Of course, it's all laid down in Section 108 of the Constitution. And then, once Parliament votes, and the bill gets a vote of 2/3, that is when it goes to a referendum. So we're still on track. We haven't attempted to set any process, but to give this impression that because entrenched provisions are included in this bill, that means government is trying to play some game. It's misleading. I think it's misleading, and I think as leaders, we should do our homework and then be able to inform the public, especially people who want to govern in the right way. Again, the other thing I must say.
We have to see that one.
Yes.
We are live on here.
Right.
Please take your time to explain.
With leave of the leader of government business, SO2, as they say in Parliament, I'll explain this in Creole. Now, government no say, there's section yaso, like section 87 and 85 of the Constitution na entrenched provisions. And for entrenched provision, it therefore go to a referendum. But the Constitution very clear. Before you take this to a referendum, you therefore bring come first as a bill na Parliament. Parliament they debate, a vote, and when that vote they come out, 2/3 in support of the bill or the specific amendment. Now that 10 day it will go to a referendum. So people around the talk say government don't count entrenched provision inside, so they no go referendum. The referendum now the last step. The bill they come first na Parliament. Parliament debate, a vote. If Parliament vote for the bill by 2/3 members of Parliament, then it will go to a referendum. So if anybody tell the public say government don't count entrenched clause wey for don carry go referendum, that person dey not do im homework yet. A misleading for the public. And that is why we don't be very open about this process. If person get question, you able ask, we will explain. They're always open and ready for provide clarification. And not only for question. If person gets suggestion, you want count and to be, please do so. And we don't be open to suggestion. We don't take plenty suggestion throughout this process here. Now the other thing we are foresee. If anybody tell you say an entrenched provision and a non-entrenched provision not go dey inside the same bill for amendment, not to so the Constitution say. The Constitution not say where you dey come, if entrenched provision dey, you for kick am out first and can separate. The Constitution dey very clearly how you dey amend the bill. And then how you amend the Constitution. And then it adds here, if any of them provisions here so, they lay them out in the Constitution, need for be amended, after Parliament don't vote, it will go into a referendum. So yes, we are aware. One thing where we don't say very clearly, now that when we complete the electoral reform process, the proposals will touch on elections. Once we complete that, we will continue with the broader constitutional review process, we will lead into a referendum. But we just want to make sure, see, all the proposals from both the Cowan report and the tripartite report will touch on elections, we bring them come as one package. Now with Parliament doing work, then we'll put transition clause and say let me just wrap this up to say, that is where now Parliament can come and say, get transition provision. Say yes, this no good in a certificate. I think the Deputy Speaker of Parliament did an amazing job on 98.1 this morning explaining this process. That if this bill is enacted by Parliament, then the proposals that touch on entrenched clauses in the Constitution will not be part of the certificate that the President will sign. That certificate will only apply to non-entrenched provisions, because we are aware that entrenched provisions will go into a referendum, but at least we'll have taken out the elections-related provisions and then we'll move on. I hope that makes it clear. We have also proposed that in case a candidate is standing trial on a criminal charge to which the state is a party 1 year prior to election, such trial must be suspended until after election. This is something we discussed on tripartite committee, and we have put in here. So it's a proposal. But if you look at the bill, we have also said put additional layers to this, which is to say, like you have in other countries that we have looked at, persons who have been convicted for certain offenses cannot be made to run for office, but that restriction will expire 5 years after they have served their sentences. So it's not, you don't lock someone out of the electoral process for the rest of their lives. That is an addition I think would be very public, that it's something that we have included in the bill. And then, so this again has generated some form of misunderstanding. So here we're proposing that, and this is actually from the Cowan Constitutional Review Committee report, that we include in the Constitution that the loss of party membership alone will not automatically remove someone from, will not automatically remove a sitting president or vice president. Let's be very honest, that the Samsumana case is a clear example in front of our eyes, because that vote sits with the people. And so we're saying that that decision to remove a sitting president should not be taken by a few actors within the political party. We're saying that if that happens, then the existing provisions in the Constitution should apply. I know, of course, that part of the public discourse has been that we put in a new proposal to give Parliament the powers to remove the President. The fact is that that is a power that Parliament has already. So this is a power that Parliament has already. The procedure is laid out in the Constitution. So all we are saying is that if a sitting president or vice president loses his or her membership in the political party that supported their candidacy, doesn't mean that they automatically cease to become president or vice president. It means the procedure laid out in the Constitution already will be triggered. So that way, it is not left in the hands of the president. The option for this will be to continue with the current system, wherein the president can determine whether he or she wants to continue to work with the vice president or not. That is the current system. But then to have that additional oversight as laid out in the Constitution is the right thing to do. It's something that we discussed extensively on the tripartite committee and then laid out. And I think, when I say that we should all take ownership for these proposals, these are the things that I mean. That, when they come up in the public discourse, persons who have been part of this process should not be isolating these proposals. I think we should all state why these proposals are included. So that is really what we explain as a gap in the Constitution. So that the provisions apply. This was in the Cowan report after extensive consultations. This is a recommendation that the Cowan committee made, and that is why we have included it in this bill. And then we come to the preferred electoral system. I like to say, as Honorable Deputy Speaker of Parliament said today on radio, it looks like it's the elephant in the room. Again, I was very intentional when I said earlier that the tripartite process was not meant to undo existing government reforms or commitments. But what we have from the process that has gone through the hands of successive governments, which is the main constitutional review process that we've been engaged in for over 20 years, the Kawan Constitutional Review Committee, after broad consultations, I gave you the figures. After broad consultations, after looking at best practices in various countries, recommended that this country must transition permanently to the proportional representation system.
Yes, sir.
And it is in the white paper. I also like to say,
Honorable members,
There'll be time for debate.
please, I continue to have your attention.
I also like to say that I like to go to the Women's Manifesto because it's an important document. I like to hold on to it. When women's groups commended government in that manifesto, that 12 of their proposals had been included in the government white paper. One such proposal was this. Matter of fact, I like to quote it. They say to ensure peace and cohesion in Sierra Leone, the proportional representation system must be entrenched in the constitution. So these are processes, and so we acknowledge that every electoral system has its own challenges. We acknowledge that yes, the PR system in the last election had its own challenges. Yes, since we transitioned to multi-party democracy from 96 to now, we have had 6 elections. In 3 of those, we have had the first past the post, which of course has had its own problems as well. In 3 of those, we have had the PR system. In 96, we had the wartime model, we like to say, which means the entire country was a single block. And then 2002 and 2023, we used the district block representation system. So just going by our example in Sierra Leone is to say there are different variations of PR. So I think what this is supposed to do is to rally all of us around a table to have real, honest, technical discussions on what kind of PR will work for Sierra Leone. Of course, it has its own challenges. I've gone to communities where persons have said that they were not involved in determining who gets on the list to represent them in their districts or constituencies. That is a challenge that we must address. There are options to address that, right? So let's have all of those discussions. But we also acknowledge that having to deal with the problems that come with by-elections is challenging for this country. The violence that we have to deal with, the economic impact. Matter of fact, since 2023 to date, government has actually saved over 20 million leones, or if you want to put it in the old currency, 20 billion. If you want to put it in dollar terms, it's close to $1 million just by not conducting by-elections. And those are monies that government has been able to direct towards free quality education, and food security, etc.,
Please allow the minister to finish, please.
All right. So
No,
So
that's
we look at these processes, like I said, recommended by the Cowan Committee after all of these processes, and then of course, through other mechanisms. Now, how does this compare to the tripartite process? I think it's good to also put that in context. Now, the thing is, the tripartite committee, in the report that we submitted, of the 80 recommendations we agreed on, we did not recommend one system over the other. Yes, we discussed it in the tripartite committee, but right at the onset, we knew that we had opposing views on that process. And so what we agreed on and put in the report was that we should convene a national dialogue on a preferred electoral system for Sierra Leone. That's what is in the report. And then, of course, the government took that recommendation very seriously. We agreed to conduct the national dialogue. But because we wanted the dialogue itself to be really participatory, we added another layer. We said, before we get to the national dialogue, let's do countrywide consultations. And so we had expert facilitators, 3 of them, and then other actors who supported the process, International IDEA with funding from the European Union, and then we put a team together to support this process. That led to consultations, regional consultations across the country, and then that led to the national dialogue. Now, for the national dialogue, after the national dialogue, a report was prepared. We received the report. We made the report public last year. We shared the report with various stakeholders. So you say that report is actually the product of the approach that the tripartite committee recommended. But then in that report, the report does not state a preferred electoral system. It does not state one system over the other. The report, in summary, says there are certain people, a significant percentage, that supports the first past the post system, and these are their reasons. And then other set of people, significant percentage, that support the PR system. But then, noting that if we go with the PR system, we should reduce the threshold. And that another set of people prefer a hybrid system as is applied in certain countries. So that is what we got from the national dialogue. Now, it was going to be unrealistic. So now say, all right, the national dialogue has not given us one system over the other, so let's go back to tripartite and go get into a disagreement. We looked at it as though, yes, people have preferences for the various mechanisms, and that there were existing recommendations from the Cowan process. As noted again, the tripartite process was meant to complement the Cowan process, not undo or override it. And in the Cowan committee report, which was accepted in the white paper, it was recommended that we transition to PR. So if the tripartite process didn't make a specific recommendation on that, we will go with what is on the table. Now, that is why we have this. Now, I think another thing that I should take this opportunity to clarify is there's been in the public domain, and also I think presented by leadership of our brothers and sisters in the APC, that the civil society, there's a civil society report or exercise that lays out the percentage of persons who support first past the post at 57, and over 30% support a hybrid system, and that 10% support a PR. and that these persons or the civil society representatives took a vote at that meeting. First, for disclosure purposes, I attended part of the meeting. I delivered the keynote, and I think it's an engagement that I welcome, and it's an engagement that I will welcome on the provisions in this bill as we move forward. I delivered my keynote, I left. I know that when my comrade got the mic at the time, I think his first complaint was that all the speakers had spoken in favor of PR. I think they had to make the record straight. But now I provide this context to say that those figures that several persons have talked about, including the leadership on the APC side. Maybe they have seen the report. I have never seen it. And I think as a person who was managing the national dialogue, my office was managing that, I think the understanding was that the report will come to my office and then we'll discuss it. But as I say, I cannot speak to that as to how we got to those numbers. I cannot even make any judgment on those, etc. Because they have never been before me. And so if you ask me why that data or the outcome of those deliberations were not considered in this, it is because, in all honesty, they were never before me or before any member of my team. And so, you can't consider or take on board something that is not before you. And so we went with the Cowan recommendation. But we also note that PR has its problems. Like any electoral system, of the more than 100 countries that practice some form of PR, actually by data, majority of the world's democracies actually practice some form of PR. In fact, there's data that shows that in a lot of countries where people are happy with their governance system, they have a PR system. So for me, the question is, how do we, as a country, get together and discuss the PR system that will work better for us? And so that is why, because we do not have the answers, that is why we have proposed that, yes, elections will be conducted through a system of proportional representation, but we want greater discussion on the mode, the method of nomination, and the conduct of such elections. We all want to get around the table, discuss, and come up with a model that works for Sierra Leone, and then that will be prescribed in a separate law by Parliament. So yes, we've done half part of it, but then I think let us all get together and do the remaining part. But really, when you consider the processes that various governments have managed and where we are, yes, we believe that maybe we should now transition. In our discussion, we should now transition to the kind of PR that we want as a country. That is the discussion. But again, it's a proposal that we've made to Parliament. Let us all discuss it and see first if Parliament agrees that PR is what we'll go by, and if they agree, we all get a discussion as to the kind of PR that will work for this country. And this, what we have here is the provision in 76(1) on whether dual nationals can run for Parliament. Yes, both processes in Cowan and the Tripartite Committee proposed this, right? But we note that it has been a challenging subject for our members.
Order, please. Order, please. If you want to have discussion different from what you are doing, please, you can move out and do so. We need to listen to the presentation. And he's doing a very, very good job for all of us. We can use this in our debates. But undertone are so loud that you can't even understand what he's saying now. Yeah, I will be with that. Go ahead.
So this was actually meant to amend Section 76 and and make it possible for our brothers and sisters who have spent time in other countries and during this period have obtained the nationalities of these countries, but who still remain Sierra Leoneans by virtue of our amended Citizenship Act, to be able to run for office if they so wish. But yes, we understand that it's a challenge, but then the impact that this provision has is, as currently framed, when it applies to members of parliament, it also will apply, as has been argued, to persons serving as ministers. And so, of course, the presidency, I think, will be very clear. We discussed on the tripartite committee that for the presidency, it should be secret. If you want to run for president and have a nationality of another country, you should let go of that nationality. But then for all the positions, I think we even suggested having safeguards, which is, one would be, if someone wants to run for office, you should provide proof that you have been physically resident in Sierra Leone for like 3 years or 5 years, in Sierra Leone, as someone will say, as someone will say, SO2, make welcome Sierra if you are on for office. So, but what we're saying now in this bill, this is an option, but the other option is that if there's a restriction on running for office, that restriction should not apply to appointment as minister. So that is in the bill, but we'll discuss that.
Order.
So also there's a provision in our constitution that says a public officer who intends to contest an election should resign from such office at least 6 months, at least 12 months before the election. On the tripartite committee, we discussed this extensively, and it was our proposal so that be reduced to 6 months. But then, as government, because we want broad participation, we included another layer, because the question has been, what's the problem that we're trying to solve? And I like to give the example of the teacher or the healthcare worker who say in their community, highly respected, mentors to so many people in that community, and they are the persons that community really trusts to represent them in parliament. By this provision, we basically say such a person, I'm a teacher, whether secondary school or primary school, we're asking them to live in poverty, not be able to take care of their families for 12 months before running for an election. And so we consider that as government and say this place should be open. So in addition to reducing it to 6 months, in the bill, we also made some modification. We have amended the Anti-Corruption Act. Before now, everybody was required to declare their assets. But then we amended the act to make it a requirement for persons at a certain grade to declare their assets. And so we are proposing that this requirement should apply to persons who fall in that category, who by the Anti-Corruption Commission Act are required to declare their assets. But other persons who are below such grade and are not required to declare assets, such as like a teacher or healthcare worker, this provision should not apply to them. That is the proposal that we have made. On the tripartite committee, we also wanted to make emphasis on the neutrality of security forces during elections. And so that is why we proposed an inclusion of language in sections 155 and 165 of the Constitution, having to do with the security forces, the police and the military to say, one, in the exercise of power and their powers, they will not act in a partisan manner, will not further any interest of a political party or cause, will not prejudice a political interest or political cause that is legitimate under this constitution. So that has also been proposed as an amendment. We have 165 minutes to go. So I really think that these are the proposals that we have worked with our drafting team to put in this bill. And as I said, they are from these two sources that I've explained. And I'd like to close by emphasizing again that this is a bill. It is a bill for a reason. It is not a perfect document. We want to have broad conversations. We want to have broad discussions and really make sure that what comes out of Parliament is significantly better than what we have submitted to Parliament. I think if we all work together, we can make this something that will work for Sierra Leone and will really strengthen our governance and electoral architecture in this country. Thank you, Chairman and leaders of the country. Thank you very much.
Thank you very much. Again, yes. And now with the, I'm happy my Archbishop is here because at this point I think I would like to quote from the Bible. I think Matthew 22:14. Many are called. So, again, not all of us will be able to ask questions. But like the AG said earlier on, the conversation is going to continue. This is a proposal. It's our collective responsibility to make it a document for the people of Senegal. So now, we're going to open the floor for questions. And we want to encourage MPs, because earlier on I told you to carefully take your notes. And this is the time to ask your questions. The floor is open. Just raise your hand in different segments. Just raise your hand.
Mr. Chairman. Mr. Chairman.
Yes. I want the mic back because you don't have to give the mic when I haven't given the instruction who to give the mic to. I'll be mixing it. MPs on the left, and of course key stakeholders on the right. So I'll be mixing it in that particular manner. Yes, the chairman, PPRC.
Thank you very much, Chair.
and very good afternoon.
Yes, I'll give you 2 minutes.
Grateful. Chair, let me stand on existing protocols. I'll go straight to the proposal to amend Section 34 of the Constitution as it is right now. Care must be taken to actually fully understand what the Attorney General and Minister of Justice said. The Justice Cowan review of the Constitution had been concluded but was yet to be adopted. And between that time and today, we had our act, the Political Parties Act, repealed and replaced in 2022. You realize that the change of name for the PPRC was a desire to actually give it regulatory powers. But that one has been called in the 2022 Act. Remember, it is now Political Parties Regulation Commission. So it now has the power not only to register, because regulation includes registration, not only to register, but to regulate. So I would say with humility that that which was sought to be called or to be addressed in the Justice Cowan review of the Constitution by making that particular recommendation has been called, and therefore there is no point changing the name from PPRC to PPRRC or PPPRC, because it has been now resolved. Now we have regulatory functions, and regulation includes registration. So it will be repetitive to now call it the Political Parties Registration and Regulation Commission. So that change of name, I'll request be considered in your debate in the instant circumstance. And of course, in regard the issue of political parties who, when they lose elections, should be deregistered, which comes as a proposal. Political parties are not our clients, they are our partners. So the political parties will have to make a representation in that regard. Thank you very much.
Thank you very much, Mr. Chairman. I've taken one from this end now. I need to go to members of parliament. Honorable members, you are representatives of your people. It's a bit strange that I haven't seen your hands up. Honorable Timbo.
Thank you very much. I don't know if the minister is still around. Is there?
Yes, yeah.
Firstly, I want to commend the Minister of Justice for quite a passionate and statesman-like opening statement, and that this document we're dealing with should look beyond politics, should look beyond political parties, and we know that constitutions are not made just for the short time but for even the long term. I will not go into specific provisions because this is just the start of the process. And as a member of the Legislative Committee, I have a lot of things. My party has a position also which we'll present within the arguments. That's what we will leave when we're dealing with the document in the Legislative Committee. However, I have 3 points. Firstly, the Minister of Justice has been really transparent in the things he said leading up to this point, talking about the engagements they've had, the inclusion of many people in this process. But one thing he said is that this document contains some recommendations from the white paper, the Cowan report. And like he said, there's been development now. As it is, I don't know how popular this white paper or the Cowan report is, how much it is in circulation. So as this document is out, the bill is out and the tripartite report is also out. I appeal to you to make the white paper or the white papers and the reports of the Kawan committee also known to us, because if you make a reference to it, we want to compare it side by side. As you said, this document has nothing extraneous, has nothing new. We want the the Kawan reports to also be made available to all of us. Secondly, you made mention of certain things in your presentation, particularly in the provision for the amendment of Section 35. And from the document that we have, the bill that we have, some of the things you said, I haven't seen in my copy, the one I printed myself as well as the one that was given to us. We just want to know whether the one that has been circulated is the final version. For instance, Section 35 that talks about deregistration of political parties. I haven't seen that in the bill that I have.
No, you say your party.
Yeah, proceed.
And finally, I want to make legal reference to what the Minister of Justice also spoke about, entrenched clauses, particularly 1083 of the Constitution. And I want to say I beg to differ in saying that while the bill will still be presented to the President, but the provisions that are entrenched in the Constitution will not. By the letter of the law, that is not what Section 1083 says. Section 1083, with your permission, I'll read. It's very clear. Section 1083. I read. A bill for an act of parliament enacting a new constitution or altering any, the emphasis is on any, of the following provisions of this constitution. I don't want to repeat all the sections, but you spoke about section 85, 87, which are entrenched clauses. And it says, shall not, that's the bill, shall not be submitted to the President for his assent and shall not become law unless the bill, not unless the provision, unless the bill is one holistic document. It is not a provision unless the bill, after it has been passed by Parliament and in the form in which it was so passed, the bill in its entirety, in the form in which it was so passed, has, in accordance with the provisions of any law in that behalf, being submitted to and being approved at a referendum. This does not refer to a section. It refers to the document in entirety. So I understand where the leader of the opposition is saying we'll kick against any provision that touches or concerns entrenched clauses in this bill, because this document should be taken in its entirety, and this is my submission. Thank you.
Thank you very much, Honorable Mfakuruma.
Thank you, Mr. Chairman. Mr. Chairman, honorable members.
Order, honorable members, order.
We definitely want to appreciate this document that is in front of us. And I'm happy that the whole country has an opportunity to see what we have been confronted with. My question and the issues I want to raise are with section 32 that speaks to section 3, in which an electoral commissioner should be appointed. We know with elections in this country, we know there are issues that are very political. And I always hold this view that to fix a political problem, we need a political prescription. So, in recommending electoral commissioner to the president, it is a political problem that demands a political solution. Though we believe that interreligious community should be included, though we believe that the Labour Congress should be considered, though we believe that youth groups and women organizations should be considered, we also believe that politicians and political parties should have a say in the recommendation of an electoral commissioner to the president. We cannot leave politicians out of that equation. So for us, I believe that is something that needs to be revisited and considered, so we can have something that's cool in the future, will not be controversial. Because we know as a country, we all have respective political lenses. And if that is the case, we can choose respective people in all these organizations, but they possibly will have one political lens. So that is why it's imperative that we all consider including political parties in this equation, because this law should be able to stand the test of time. The second part of this one, Mr. Chairman, is the area that has to do with census before elections, or what census results we should be using. I'm glad the Minister, the Attorney General, Minister of Justice, said they are open to proposals. And it is critical because now we know we have a census that is going to happen 2 years before elections. And we've not had a census, a national census, since 2015. Though we had a midterm census, but we can recall that in that midterm census, it was not accepted by even ECSL at the time when the Public Elections Act came, or the bill came to Parliament, which caused the ECSL to recommend that we have a prescription for that election in which there was an average done for the people that were counted. So if we're going to have an election and a census, though this law could be the law to stand the test of time, but these elections and this cycle should definitely be an exception in which the results from this census should be considered for the next election. And I must go on record to state that the APC has fully supported the census, and the APC will fully support the census. I know I don't have enough time because I want to give the platform to other speakers.
Thank you.
So I'll just end on 42(2)(e) that talks about elections and the majority of what will be considered in that election. So for the 2(e), for the listening public, it states that no person shall be elected as president of Sierra Leone unless at the presidential election he has polled not less than 55% of the valid votes in his favor. I will say, and I will conclude, that there is no reason. There's a common saying that says, if it's not broke, don't fix it. The 55% is not broken. So let us now endeavor to change that. Because the 50 plus 1 and the 20% as proposed in this bill has other rooms for other issues that we will struggle with as a nation. So definitely, I believe that the 55% will allow even political parties to come together, though this bill is also proposing the registration of political parties, which the APC do not support and do not agree with. We believe all political parties should have a say in the elections of this country, especially it has to do with representation. We believe 55% should be the one that should stay in the books, and 50 plus 1 and the 20% will not be one that will stand the test of time. And it will not even survive under the PR, which I believe somebody else will talk about. Thank you, Mr. Chairman.
Thank you very much. Now, one more from this end, and then AG will respond. Yeah? Order.
Thank you very much for the opportunity, and thank you for making us be part of these.
Order, honorable members.
Thank you for making us be part of these deliberations. Actually, being here, I am more reassured that we're going to have a constitutional review process that is transparent and that is open. And I want to commend my darling, the Clerk of Parliament, in reassuring us, and members of the High Table that have indicated to us that we're going to have a constitution that is based on consensus and consent. We're going to hold you to that promise. Now, I am not going to go into the position statement of Elraj because I know that you already have it, and the AG has already promised, and the clerk has already promised that you're going to look into it and take some of it into consideration. I just have some observations based on the presentation of the AG today. I would like to draw your attention that contrary to your presentation on clause 1 of the constitutional amendment, you made a reference to the mandate of the Search and Nomination Committee in your slide, but I would like to mention that it's not in the bill. Should I repeat? I know that you made mention in your slide of the mandate of the Search and Nomination Committee, but that is not mentioned in the bill. Secondly, you did mention and you emphasized that this bill is consistent or is a product of the Cowan recommendation and the tripartite recommendation. There's nothing there that is government creation. I must say, with all due respect, that is what has created the confusion. That statement is what has created the confusion to the public. Because upon closer scrutiny of the bill, juxtaposing it with the Cowan recommendation and the tripartite, you will indeed see that there are deviations, some of which are partial, some of which are outright. So, in order to reduce the tension and the confusion and the controversy, I would most respectfully advise that you don't have to justify that it is exactly the same like the Cowan recommendation and the tripartite recommendation, because that is where you create confusion for all of us, because it is not. Also, AG, even where there are alignment, even where you say even where you say there are alignment between the Cowan recommendation and the tripartite recommendation, and that's the reason why you adopt some of these provisions and you call them mere modifications. They are actually, in fact, a creation by the government because they defeat the purpose of the values of the tripartite recommendation, which is inclusivity, participation, and sovereignty of the people. I can give you a simple example. For example, Section 32, we are seeking to amend.
Honorable members, this is an opportunity for us to clarify things here. Let's grab that opportunity, please.
For example, Section 32 that we're seeking to amend with reference to the appointment of the chairman of the Electoral Commission. The tripartite recommendation says that the members of the Search and Nomination Committee must be administered by the Public Service Commission, must be established by the Public Service Commission. However, we have given the power to the president to appoint, which means even though it is partially aligning with the tripartite recommendation, it is deviating from the intent, which is to reduce the discretion of the president and to insulate the chief electoral commissioner from executive interference. So when we say that it is not government creation, we should be careful, because if you change the rationale behind the recommendations and the intent behind the recommendations, it comes across as an imposition. And one last observation that's got to do with clause 9 and 11 of the bill, quickly. They seem to contradict each other. On the one hand, the AG has explained here that we are not introducing a new ground to remove the president when he is expelled from a party or when he resigns from a party. But it is categorically there in clause 9. It seems like that is what we're doing. We're increasing another ground or adding another ground for removal. Yet, clause 19, which talks about the vice president, which is similar to clause 9, says that it should be subject to section 51 of the 1991 Constitution. And by the way, that recommendation is contrary to the Cowan report and is also not in the tripartite recommendations. So again, we have to look into that, because if we leave both of them in the bill, it will create confusion. We'll have to decide, are we going with clause 9 or are we going to clause 11? Because clause 11 seems to amend and remove the effect of section 50, and whilst clause 9 seems to retain section 50. Thank you very much.
Thank you very much, and I'll now call on the AG to respond. Honorable members.
Please, honorable members, please, this session is very important. Let's continue our methods. Thank you, colleagues. I'm hoping that we will have.
Hold on. Again, this is a gentle reminder that we're representing the people of Sierra Leone. We can't bring all of them in here, but some of us are privileged to be here representing them. Let's represent them to the best level. Thank you.
Thank you. Like I said, Chair and leaders and members of Parliament, I'm happy that we're having this conversation, and I'm glad we all make a commitment. We've all made a commitment that this will not be the end of it. I think, outside this room, we will also have these conversations with various actors, conversations that are not, just convened by members of Parliament. So we really get into the technical details of some of these proposals. I'm happy to discuss with the chair of the PPRC. But the point is that yes, in the Act we have said political party regulation commission. Now the point is the recommendation is to be very clear, because registration and regulation are two different things, right? They're two different things. To register, to take responsibility for registration of political parties, and then take responsibility for regulation of political parties are different. But we'll have that discussion, and then we will figure out together whether we go with the recommendation that you will be very specific on the registration mandate of the commission, or whether its work is covered in its regulatory mandate. So we'll discuss that. To my brother and colleague, and to add another comrade of the Radicals Club, Honorable Timbo. Our numbers are the opposition APC. First is to say that yes, these documents, as much as yes we say they have been public documents, we will do our part to share them again. Matter of fact, the Minister of Information and Civic Education is here, and we have been working together on a very robust public education program. He likes to correct me because we don't want this to be just information sharing. We want a process that we can call an engagement with members of the public. Yes, we want to listen, we want to learn, and we want to incorporate feedback into this work. And so, as part of that public information strategy, this week actually, we will be, today, he has said today actually, we will be launching a website for the constitutional review process. And so everything will be out there. The documents that we have referenced here will be out there. And so you have our word that these documents will be available. I think we seem to have a disagreement on our readings of section 108. Respectfully, I think our readings, but I think I'll engage but not preempt, how you will look at it in the legislative committee. But I think our readings of it are different. I'm glad that my colleague and sister, Mrs. Michael, spoke about the letters and the intent. I think, we'll have to go into what the intent was. But it is just to say that we know that at this point, we don't really know the form in which this is going to go to the president, right? Or the form in which it is going to come out of Parliament. But that form will actually, determine what goes to the president or what becomes part of a broader package for a referendum. But I think it's to say respectfully that our readings of it, taking it that it has to be in a separate bill because of the use of that word, is very different. But we can discuss that as colleagues, and make sure that when it gets to the legislative committee, I think we are all on the same page. Yes, and on the appointment of the ECSL chair, I take your point, Honorable, that political actors should be included in the process. I think when we discussed this on the tripartite committee, we did not consider that. The idea was to really take that decision-making process from the hands of the political actors. I think we tried to look at the Kenyan model in which the search committee appoints the chief electoral commissioner, and then what we try to get like a blend with our own system, where like you don't take out the president's powers completely, but to say yes, the search committee will do its part, and then you will recommend to the president, and then the president will select from that group. But this is a discussion that we should have, because you're not the only one who has said so. In discussions with the other political parties, the All Political Parties Association, or let's say the other 15 political parties, they also expressed the same concern that political actors have been taken out of the process. So I think this is a discussion that we should have, and again, I emphasize that is why this is a bill. I mean, all of these discussions should really enrich, the outcome of this exercise. So by all means, let's have. So we'll talk about that. Census results to be used. I think we have made our own proposal on how that clause should read. Whether we have a transition clause in there on when it comes into effect. I think let's discuss that. But again, it's before you. We're happy to discuss all of these options and come up with something that will work for all of us. Section 42, I think we'll discuss, but I think there's really broad. When the Cowan committee looked at it, when the white paper discussed it, when we discussed it on the tripartite committee, yes, there was our view was that it's broken, it has problems, and really, if we look at best practice, in the region, we struggle to find a country that still uses that system. So we also took note of the challenges we've had to deal with when we're going to runoff elections, and say, yes, what we propose now does not eliminate the chance of a runoff completely. It's still possible, but it reduces that chance substantially. So let's have that discussion as well. To my colleague, Mrs. Basita Michael. So, I think I like to say respectfully, when we have audiences that listen to us, I think it is good to do our part in getting the information right that we send to them. Because in this day and age, you say one thing, yes, just like me, right? I say certain things, people will question, but then there will be people who will move on with that. So when we say certain things and try to state them as authoritative positions, I think we should be careful. What you state about doing this, I can't quote your exact words, but within the Public Service Commission, a process that will be set up through or within the Public Service Commission, that is not true. That is not what recommendation 36 says. 36 talks about yes, the search and nominating committee for the appointment of electoral commission and chair of the PPRC, right? And talks about 9 processes, including one from each. It lays out Interreligious Council, Bar Association, Civil Society, Labour Congress, Sierra Association of Journalists, Women's Organizations, Youth Groups. And the only mention of the Public Service Commission is that the search and nominating committee to be supported administratively by the Public Service Commission. I think let's be very clear the way we put this. It is an administrative support. The Public Service Commission doesn't even have any role in the constitution of the body. So let's try not to give that impression to members of the public. It only says the search and nomination to be administratively supported. It's just to provide an administrative support. It has nothing absolutely to do like its constitution and the way it carries out its mandates, etc. It's only to provide administrative support. So I think let's be very clear on that, and I think let's be very careful in the way we communicate these things. I still want to say, in the spirit of the same comments that I have made, the way we communicate this to other people, I like to hold myself accountable. And I have been very clear. The moment this was put together, since last year, I started saying that a few of the proposals have been amended. I was very public about that. These are not things that have taken place in hiding. And yes, you might say that when you amend certain proposals, you might alter the intent. That is true. That is true. But I still go by what I have said consistently since last year, that the proposals in this bill are not creations of government. They are creations of these two processes. But I have said that there are certain proposals that have been amended, but that is how government functions. So now, let's put it this way. I've been in government a few years. I'm still learning, right? And you know, I learn from people in government. I learn from people who have served in government. In fact, next to you is my big brother and partner. We call ourselves a partnership on the tripartite committee. When we served on the tripartite committee, and sometimes when things were difficult to handle, the entirety of the committee would put it in the hands of myself and Dr. Richard Conte and say, you are the partnership, get a solution. And we will hand heads. We will look at options. We will engage various individuals on our respective takes. And then we'll come back with proposals. Most times, the entirety of the committee will adopt the proposals that we bring. But during this process, noting that, you know, he has, of course, lived in this world longer than I have. He has served in government in various roles, in the office of president and, you know, in various ministries. I've had to learn a lot from him, right? Same with Dr. Mara, I used to say so. So I'm still learning. So, but one thing that I know during this time that I've been learning is that when bodies make recommendations, they are called recommendations for a reason. They are not called directives. They are called recommendations. If you go back to, let's even take it to the Truth and Reconciliation Commission report. When the TRC issued its report, handed the report to late President Kaba in 2004, there was a white paper. And then, of course, we saw with other commissions of inquiry that we have set up. The Shares Moses Commission of Inquiry, inclusive. And then, you know, you come to the Kawan Constitutional Committee report, 2017 white paper. And then you come to the 2022 white paper. If you read these, you will find three common things. One is government rejecting some to say we cannot do this. That's deviation. But 2, government accepting these recommendations. And 3, government accepting with modifications. That's how government functions. Check the various white papers. That's how. So it is okay, government will accept with modifications. Yes, those modifications might affect the intent of the provision, or they might alter the outcome in certain ways, right? So and the point is that we have not hidden away from this fact. I came out publicly before anybody could point it out that yes, there are certain proposals that have been modified. I discussed this because that is how governments function, right? And so now that we have had these modifications, we have laid them, we have again said that even on these proposals that have been modified, we want to have additional discussions. Let us use these discussions to determine whether we keep them in their modified form, or we take them to the original proposal, or we get rid of them altogether, or, let's just say how we make the provisions better. That is what we should do. And I think that should be part of what we communicate to our audiences, especially when we know that the room is still open to have these discussions. Instead of, putting it as though, certain people have taken certain positions, that are completely out of the way. I think the way sometimes, these are received, they undermine the processes that we are all trying to make better. So on this, again, you have my word, and I know I'll speak for government on this, and buttress the points made by the leadership of Parliament, that we are open to having discussions about this. We are open to looking at different clauses, looking at variations. There are proposals here from the tripartite and Cowan processes that we might even want to review and make better. So let's have these discussions. I think it's an opportunity for us in government to learn from you. It's also an opportunity for you to, get the rationale for certain things. At the end of the day, we'll find common ground. No guarantees that we'll agree on every letter, but I think we'll make significant progress and find common ground to really produce something that will be good for the people of this country. So please, we have not attempted to defeat the purposes of this. We have good reasons for the modification. I think even in the bill, when we said that the president will appoint a search and nomination committee with representatives from these various bodies, yes, maybe we need to make the language more direct and say these bodies will nominate their persons, right? Maybe that's what we need to do. Maybe it's a language. Maybe we will say, if you go to the Agreement for National Unity, Clause 3 of the Agreement for National Unity, Clause 3 actually says the President will constitute a cross-party committee for electoral systems reform. But how did we interpret that? The President actually asked the opposition to submit their names. That is what happened. It did not translate into the President making the individual appointment. So clearly, yes, let's not leave it open to ambiguity. Let's make it better, and so we'll work together. But yes, grateful for your feedback, for your very kind comments, and really happy to work with you on this.
Thank you.